see here, I have for plaintiffs on the pleadings, Mr. Gallagher, Mr. Sheridan, Mr. Wisenhunt, Ms. Patelis, Ms. Wagstaff, Mr. Dodson, Ms. Willems, Ms. Barnett, and Ms. Is it Stico?
Stico, Your Honor. Yes.
Okay. And for defense, I think we have Mr. Abel and Mr. Bean. If you mute yourself, if you can't unmute yourself, let me know. I'm trying to have this set where only the speakers can be heard, but we'll see how that works. So let me first of all, I know the lawyers have read this, but these are for all the people who are not attorneys of record on this case. Let me read this email to everybody. This is an email I sent out yesterday. I think all the attorneys have received it. This email is to advise you that the hearing I have set for Friday is a case management conference only. The purpose of this hearing will be to discuss the status of the case and set hearing dates. Contrary to what has apparently been thought by some, I will not be deciding this case today. But we do need to talk about the case and decide how this case is to proceed and on what time frame and what wants to be heard. So this is an expedited case because of the subject matter and the fact that it's and there's also a demand for emergency injunctive relief, which I think is count 6 in the complaint. Normally what I see in this, well, we have two options. We can set the entire case for a final evidentiary hearing on an expedited basis, or we can set the emergency injunctive relief on an expedited basis and see where we are once that hearing is held. It seems to me, I'll ask the plaintiffs and then the defense to tell me their position, but I'm assuming the parties want to put on some evidence. Mr. Gallagher?
Yes, Your Honor. And before we get too deep, I think Ms. Taylor wanted to be unmuted. I think she's the court reporter. That might help.
Ms. Taylor. Yeah, okay, thank you. Ms. Taylor needs to be unmuted so she can tell us to stop talking at the same time. Ms. Taylor, feel free to tell us to stop if we talk more than one person at a time.
My main concern is that everybody please identify themselves when they speak.
All right, let's do that. And I will try to do it to the extent I can. And if I haven't done it, make sure you do so Ms. Taylor can get the name. So Mr. Gallagher, from your standpoint, how do you envision is the best way to go forward on this case? Then I'll ask for, I think, Mr. Abel's input. Go ahead, Mr. Gallagher.
Thank you, Your Honor. Charles Gallagher here for the plaintiffs. Our preference would be whatever relief would afford for a little quicker resolution. So if there is going to be a little bit quicker resolution by having the injunction matter heard, but not the entire case, the remaining counts, we would seek that so as to try to get as quick as possible relief as to the injunction relief. If it's going to be the same time frame, then we don't have an opinion on that, but our preference would be seeking sooner or later. And yes, we of course have witnesses we need to get in.
Okay, so how long, give me two scenarios. How long do you envision testimony we would need for testimony for an emergency temporary injunction, and how long would we need for testimony for the entire case?
We looked at our witnesses that we expect to have, and if the court can spare it, we think 2 days would probably be sufficient. That's even factoring in some blocks of time for defendants, fact witnesses, and defendant's expert witnesses.
So you think 2 days for both plaintiff and defendant? That's your estimate?
Trying to go witness by witness and give estimations. Yes, Your Honor. That's what we think is probably ballpark.
Same amount of time, whether it's final hearing or temporary injunction?
There might be a tad longer if it's final hearing. I think a lot of those are legal issues as opposed to ones that would necessitate extensive fact or expert witnesses.
All right, so let me ask Mr. Abel, if you can't unmute yourself, let me know and I will unmute you. Give me a second here. All right, go ahead, Mr. Abel.
Thank you, Your Honor. Mike Abel on behalf of Governor DeSantis, Commissioner Corcoran, Florida Department of Education, and Florida Board of Education. Your Honor, the defendants would propose something slightly different to plaintiff's proposal. On review of plaintiff's complaint, Your Honor, we believe that the complaint exhibits some significant deficiencies as a threshold matter and that we believe would result in dismissal of the case. These are issues involving standing, whether the complaint presents non-justiciable political questions, whether the complaint as framed would seek relief that violates the separation of powers doctrine. And we would respectfully submit, Your Honor, that before the court entertain a lengthy, perhaps 2-day hearing as plaintiff proposes hearing on an emergency injunction, we would ask the court to allow us to brief a motion addressing those 3 dispositive issues. And we'd ask that the court hear those on the basis, Your Honor, that the courts, and for which the first DCA has already addressed all 3 issues and has issued a recent ruling on all 3 issues. We believe, Your Honor, that
DCA's had a case on mandatory masks?
No, Your Honor, of course, in terms of standing.
I'm saying you said they'd issued a ruling on the exact issues in this case.
Right. In terms of the exact issues of standing, whether this case would present a non-justiciable political question or whether the complaint would violate the separation of powers doctrine. On those substantive issues, there is recent compelling authority from 2020 in the first DCA. And what we'd ask the court in terms of issuing a scheduling order is to allow us on an expedited basis to file a motion that briefed for the court those 3 issues. And if the court heard those issues and disposed of those issues, it would obviate the need for an injunction hearing, of course. And then what we'd ask, Your Honor, if the court denied the motion or wanted to continue moving forward toward a hearing, that the court would issue, as part of a scheduling order, dates for us to file our response in opposition so that we can brief the substantive issues on the injunction.
Okay, so Mr. Abel, this is going to be heard on an expedited emergency basis. Because of the nature of this case, I'm going to have to basically take the other 970 cases I have and tell them to wait. So I'm going to expedite this case. Is there any reason why you can't get your motion to dismiss filed by Monday at noon?
We will have a motion to dismiss in front of Your Honor by Monday at noon.
Okay.
Framing those issues that I just represented to the court.
Mr. Gallagher, is there any reason you can't have a response by Tuesday at noon?
No, Your Honor.
Tuesday at noon. Is there any reason y'all can't be ready to argue this before me Thursday at 2 p.m.?
No, Your Honor.
Your Honor, and that would be the issues raised in the motion that we would file on Monday?
Correct. I plan to rule on Thursday.
We can argue on that schedule.
I don't know what I'm going to rule because I haven't seen the motion or the response. But if I deny the motions, I'm going to expect an answer by Friday noon. That's assuming I deny the motions. If I grant, that's a different situation. Friday noon. And evidentiary hearing to start Monday. Hold on a second. That would be Monday the 16th.
23rd.
The 23rd. I'm going to say 9:30. And this is going to take up a 2-week period. I had a trial canceled. It was a 2-week trial. My plan was to work on several cases that are long overdue for rulings, but this is in the nature of an emergency. Those cases, unfortunately, we're going to have to wait a little longer. But we're going to do this.
Kristen Elwell joined the meeting.
Obviously, I didn't click everything I should have clicked. Hold on. Let me check again. All right. Well, I clicked everything I have to click. So if we have evidentiary hearing, we might as well do the whole case. I don't see any reason to spend 2 days on a temporary injunction, and whichever way that goes, then spend another 2 or 3 days hearing essentially the same testimony at a final hearing. Is there any reason why on this schedule, Mr. Gallagher, we can't go straight into your case on August 16th on the evidentiary hearing?
You mean the 24th or the 23rd, 24th? Sorry.
Hold on a second. Right, 23rd or 24th, you're right.
No problem there at all.
23rd, Mr. Abel?
Same for the defendants.
Okay, so what if I said 3 days for a hearing? Is that enough? If this is assuming we clear every previous hurdle we have in front of us, but 3 days for hearing?
We are
Okay, no one's objected, so we have 3 days for hearing. 23rd through the 25th. So let's go back. I'm going to have the motion to dismiss by noon. I'm going to have the response by Tuesday noon. We're going to have a Zoom hearing Thursday at 2. And depending upon the ruling in that hearing, we'll have an answer Friday. We'll start evidence Monday if I don't grant the motion to dismiss. If I do grant the motion to dismiss, we'll have to revise the schedule. So let me say this to you. If you have something you want me to see right away, you need to send it directly to my judicial assistant. I want you to file it, e-file it. But because of various computer issues, what you e-file doesn't automatically become available to me on my computer. So I would like to have the motions or memoranda as soon as possible. I don't know how long you plan to be, but this isn't my first case covering these issues. So I'm not going to put a page limit on you. Just a second. Okay. I'm not going to put a page limit on you, but I'd like you to give me the essential issues. I'm assuming you're going to, both sides are going to give me their thoughts on the first district case regarding opening that came out about a year or so ago, September, October, along in there. And I'm sure you'll give me a discussion of Judge Reynolds' case that went to the first district in Florida Supreme Court. That had to do with not safety issues, but somewhat related constitutional issues. I have already ruled extensively in another case on separation of powers. That's the DOE unemployment compensation case. That's not to tell you that I'm necessarily going to rule the same way, but that's just to let you know that's how I've ruled before. And I talked long enough to where I think I said everything I know on that ruling. So both sides, I think there's a transcript of that in that court record. That would have been last 2020, maybe in the summer sometime. If I'm thinking, I don't have case numbers. This is going from memory. I don't know what other issues, other cases I read on. I'm just letting you know that I want to get to the point. I want to take the time to read it. I'm going to give you a ruling. This is an expedited proceeding, and this doesn't mean I'm going to sit around for 2 or 3 weeks trying to make my mind up. I'm going to read what you write. I'm going to hear your argument. I'm going to consider it, and then I'm going to verbally rule. So I'm not going to take a lot of time to write orders. You all will be writing.
Kara Tomlinson joined the meeting.
And we'll proceed in that nature. As far as the evidence is concerned, I'll have to see what evidence we have before. It may be I want some argument. I'm sure I want some argument, closing argument or opening statement, something like that. Whether or not we have time enough for written arguments after the evidence, I don't know. We'll just have to wait and see. I would suggest to you that if both sides wish to want to work on proposed rulings on the case, assuming a couple of things, assuming there is a final hearing, you might want to start working on to let me look at a proposed order from your standpoint, whether it be the plaintiff or defendant standpoint. I do recognize that obviously there's some things you simply can't put in there because you won't have heard the evidence, but I think you could outline it. And if you get it to me quick enough, I'll read it. I'll read everything you send me, but you have to make sure you send it to me earlier than like 30 minutes before a hearing starts. So that's where we are. I'm going to ask Mr. Gallagher to draft an order and consult Mr. Gallagher's team, consult with Mr. Abel and his team on the language of it. I want to remind everybody, please do not send me anything that you do not send every other lawyer in this case. And also remind all paralegals or legal assistants in your office of that rule. When you send me something, I want to make sure it says on the transmittal, either letter or email, whatever it happens to be, that you sent this to all other attorneys.
Elise Metier
Something and you
joined the meeting.
Whether or not you do, I'm going to assume you haven't sent it to me. If Mr. Gallagher, you prepare an order and Mr. Abel can't agree with that order, you can send it to me and say Mr. Abel doesn't agree, and I'll give Mr. Abel. Usually I give 5 days, Mr. Abel, but I don't have 5 days to give you. A half day or a day to get me your version of it, or vice versa, whoever is drafting an order. But we have to do it quick. And if I'm dropping 968 cases, I expect you all to drop your cases from both sides to handle this. Once it's done, we'll move forward on something else, but my goal was to have this case resolved at this level sometime next week, bearing illness, unforeseen events, etc. So, Mr. Gallagher or Mr. Abel, do you have any questions, comments?
We will be mindful of the time constraints. Would Your Honor care that we order the title of the order, case management order, for brevity?
Yeah, I would. I think a case management order would be a good idea, and I would ask that you all put that together. Do you all want to put in a disclosure of witnesses and exhibits?
We're prepared to do that, yes, Your Honor.
Mr. Abel, what about you?
we'll cooperate with Mr. Gallagher and his team on the form of the order and try to reach agreements on as many issues as possible with respect to the
work. Please do that. Work with each other. I'm sure you'll be professional with each other. Give as much notice as possible, but this is an expedited proceeding, so we'll do the best we can. And when we get to the hearing, if adjustments need to be made for the sake of fairness, I'll obviously do that. So trying to think, this is going to be a Zoom hearing. We're not going to do any live hearings. So do y'all want live hearings or do you want Zoom hearings?
For us, Zoom is preferable. Witnesses are being different locations, so Zoom is preferable.
Mr. Abel?
Well, we're prepared to come over and argue, Your Honor, but we'll be as accommodating to all the parties. And if there's witnesses in multiple locations, we can certainly accommodate this format.
Well, I know, but Mr. Abel, I had to call a mistrial earlier this week because of a COVID exposure to an entire courtroom. So I don't plan to have any live non-jury hearings anytime soon.
Then we are prepared to argue and present our testimony and evidence through Zoom.
We'll be Zoom. We can do it by Zoom. It's not always perfect, but in some ways it allows us to go to witnesses in various locations that might be more difficult to get into town. So we'll go from there. It'll be a Zoom hearing. We may well, I'm going to check with the court administrator. He may well see if we can set up a situation where the public can see this via YouTube. And so we'll have fewer people actually participating in the Zoom aspect of it. Sometimes that's helpful to all concerned, but it'll give the public complete and full access to the hearing. And I'm going to go down and talk to them about that today. So our next deadline then is, our next hearing will be Thursday at 2. I will get Mr. Gallagher. I'm gonna have my judicial assistant send Zoom information for that hearing to Mr. Gallagher and Mr. Abel. Again, I'm hesitant to send anything to just one person, even if it's normal Zoom information, which we wouldn't necessarily send to everybody, but want to make sure both sides get represented. In the meantime, I'll talk to court administration about the YouTube, how that's set up, and we'll go from there. Any questions?
Judge Charles Dodson for the plaintiff. So just backing up a little bit to the witness and exhibit list, would it be okay with you if we incorporated in the order a deadline for witness and exhibit list by 5 p.m. on Tuesday, August 17, and on the witnesses have a brief summary of each witness's testimony on that, if that's okay with opposing counsel?
All right. What do the two sides say? Mr. Abel, what's your thoughts on that?
In concept, we agree with Judge Dodson. We would want to make those disclosures, though, after the Thursday hearing, Your Honor, and would respectfully ask to push that to Friday the 20th for those disclosures.
I don't have a problem with that. Make the disclosures no later than Friday, and I'll ask the parties to agree upon that. I think that's a good suggestion to have disclosures. Again, I want people to have as much notice as possible, but everyone has to understand this is expedited. So I agree with the concept as mentioned. I have no problem waiting until after Thursday. That's the motion to dismiss. Unless there's some reason I've been physically unable to read everything, we'll have a ruling on the motion to dismiss on Thursday. I mean, and this is not particularly unusual for this case. I try in every case to rule the day of the proceeding. So I'm not changing any particular procedure that I have. That's just I like to get everything as quick as I can, read it, and then we'll go from there. Anything else?
We'll be circulating a draft case management order probably tonight to the parties, so that'll be forthcoming.
All right, thank you. Look forward to seeing you all again, and I'll sign off. Thank you very much.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Thank you.
Bye-bye.